A lawsuit out of New Jersey could end one of the dumbest gun rules in America, and if it wins, a few states may lose their power to ban short-barreled rifles just because of a tape measure. Quick question before we continue: are you subscribed yet? Because legal changes like this move fast, and missing one can put regular gun owners in serious trouble. Hit that subscribe button now so you stay ahead, not behind. Here's what just happened. Firearms Policy Coalition filed a federal lawsuit against New Jersey's ban on short-barreled rifles, or SBRs. The case started in July 2025, and the plaintiffs pushed for summary judgment in early 2026. That means they are asking the judge to rule now without a full trial, because they say the law is clearly unconstitutional. Why does that matter so much? Because New Jersey is not just regulating SBRs, it is banning them outright under New Jersey law. If you knowingly possess one, the state treats that as a third-degree crime. That can mean years in prison. Not because the rifle is full auto, not because you used it in a crime, not because you hurt anyone, just because the barrel is under 16 inches or the overall length is under 26 inches. Think about how crazy that is. You can have a rifle, you can have a handgun, but if your firearm falls in the middle, the state says, nope, that one turns you into a criminal. That is the core of this whole fight, and this is not some tiny side issue for gun nerds arguing online. This goes right to the heart of how courts treat common firearms. If a state can ban a rifle based on a few inches, then what stops that same state from drawing some other random line tomorrow? One feature, one part, one measurement, one cosmetic change, and suddenly your lawful gun becomes contraband. Here's the part nobody is talking about enough. This case is not really about one rifle model. It is about whether states can ban an entire class of bearable arms that regular people want for lawful reasons. That word bearable arms matters. In plain English, it means weapons a person can carry and use. The Supreme Court has already said the Second Amendment covers bearable arms. So the big question becomes this: are SBRs part of that protected group, or can states treat them like some special evil object just because they are shorter? New Jersey says they can ban them. The plaintiffs say no, they cannot. And if the plaintiffs win, that logic does not stop at New Jersey. It starts there, but it spreads. Because other states still have bans or heavy restrictions on SBRs too. So a strong court ruling saying these are protected arms and you cannot ban them just because of barrel length becomes a weapon in every future challenge. Lawyers in other states would point to that ruling immediately. Judges would have to deal with it. Appeals. Courts would have to answer it. And if different courts start disagreeing, that is when the Supreme Court starts paying closer attention. Now, this is where it gets interesting. This lawsuit is also cleaner than a lot of other gun cases. It is not about a scary headline. It is not about a violent defendant. It is not about some messy fact pattern. It is regular people and dealers saying, we want to buy, sell, and possess a common rifle configuration for lawful purposes. And the state says we go to prison if we do. That clean setup matters in court, a lot. If you're finding this helpful, imagine what you'll learn in my next breakdown on the exact mistake that turns a legal rifle into an accidental felony. Subscribe now so you don't miss it. So let me break down what an SBR actually is, because this is where most people get confused. An SBR is not a machine gun. It is not some magical super weapon. It is not a rifle that fires faster because it is shorter. In simple terms, it is just a rifle with a shorter barrel, usually under 16 inches, or with an overall length under 26 inches. That is it. Mechanically, it can work just like a normal semi-auto rifle. Same basic action, same type of controls, same kind of magazine, same ammo. In many cases, the big difference is size, and that size matters for lawful reasons. Imagine you are moving through a hallway in your home during a break-in. A shorter rifle is easier to maneuver around corners, easier to move through doorways, easier to store in tighter spaces, easier for some smaller framed shooters to handle, easier for many people to control than a handgun. That is why people want them, not because they are planning crimes, because they are practical. That is also why the lawsuit leans hard on the idea of common use. The plaintiffs point to the fact that hundreds of thousands of SBRs are already registered federally. The number cited in the filings is about 870,000 as of May 2024. That is a huge number. And remember, that figure only counts the ones in the federal registry. It does not count people who might have preferred one but never bought one because they did not want the paperwork, the wait, the state ban, or all three. So when somebody says these are unusual, you should ask one simple question. How unusual is something when nearly 1 million of them are already in the federal system? Here's what most people get wrong. They assume shorter automatically means more dangerous, but shorter does not mean more lethal in some special legal sense. It means more compact. That is a big difference. In fact, the argument in this case is that SBRs sit in the same family as rifles the courts already recognize as protected. just in a more compact form. Here's a hypothetical example to explain this. Say you own a perfectly legal rifle with a 16-inch barrel. Now imagine the same platform, same caliber, same semi-auto function, same magazine, same basic use. The only real change is the barrel loses an inch. Under the state's theory, that tiny measurement shift can move you from lawful gun owner to criminal defendant. That is exactly why this case feels so important. The line looks arbitrary, and courts hate arbitrary lines when constitutional rights are involved. Now, quick legal note: this is educational information, not legal advice. Always consult an attorney for your specific situation. And please do not make this mistake. Do not start changing your rifle because you saw one headline or one YouTube clip. This case is still active. No court win means nothing changes for you until the law actually changes. I cannot stress that enough. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want the facts before the panic starts. Click subscribe and stay informed. Now let's get to the legal engine behind this case, because this is the part that shocked me. After the Supreme Court's Bruen decision, courts are supposed to ask a basic question: is the conduct covered by the Second Amendment's text? If yes, the government then has to show a historical tradition of similar gun regulation. In plain English, the state cannot just say, "We think this rule is smart." It has to show this kind of restriction fits with American history and tradition. That is a much harder test than many states want. So the plaintiffs in this New Jersey case are saying three big things. First, an SBR is obviously an arm. It is a rifle. It is bearable. Regular people can possess it. Second, SBRs are in common use for lawful purposes. Again, the filings point to roughly 870,000 federally registered SBRs by May 2024. That is not a tiny fringe number. Third, New Jersey cannot point to a real founding-era tradition of banning rifles based on barrel length. The plaintiffs argue the first real federal barrel length rule did not show up until 1934 with the National Firearms Act. That is way too late to prove a deep historical tradition from the founding period. And that takes us to the phrase in the title, State NFA bans. This is important, so stay with me. The federal NFA is one thing. State bans are another. Under federal law, SBRs have long been treated as NFA items, meaning tax, registration, and extra rules. But some states go further. They do not just regulate them, they ban them outright. That second layer is what this New Jersey case attacks. So even if the federal NFA still exists, a win here could strip states of the power to add their own complete bans on top of it. That is why this matters nationwide, not because one district judge can instantly rewrite every state's law tomorrow morning, but because a clear win creates a roadmap, and once one roadmap works, more lawsuits follow. But wait, there's something even more important. There is already a warning sign on the board. In a federal criminal case called United States v. Rush, the Seventh Circuit upheld federal restrictions tied to an unregistered short-barreled rifle, and the Supreme Court later declined review in December 2025. A lot of people saw that and thought, well, that's it, SBR challenges are dead. Not so fast. Rush was a criminal case. This New Jersey case is a civil challenge to a state ban. Different posture, different arguments, different record, and maybe most important, this case puts the court face to face with the cleanest question possible. Can a state make peaceable citizens felons for possessing a common rifle configuration? That is a stronger message than, can the government prosecute this one defendant after the fact? Courts notice those differences. Let me explain why this matters in the real world. If New Jersey loses, the ruling could be used immediately by lawyers challenging similar laws elsewhere. Even if the ruling only directly binds New Jersey, its reasoning can travel. If an appeals court backs it up, that reasoning gets even stronger. And if another circuit goes the other way, now you have the kind of conflict that often pulls the Supreme Court back in. This is how national change usually happens, not in one giant movie moment, case by case, state by state, ruling by ruling, until one day the old rule just cannot stand anymore. So what should you watch next? Watch whether the judge says SBRs are protected arms under the Second Amendment. Watch whether the court treats the state's ban as a total prohibition instead of a minor regulation. Watch whether the opinion leans on common use, and watch whether the court says barrel-length bans have any real historical twin in early American law. If the answer to those questions breaks the plaintiff's way, this case becomes a big deal very fast, and here is the practical warning. Do not assume a lawsuit filing equals freedom. It does not. Do not assume a district court order means every other state is instantly toast. It does not. And do not assume federal and state law move together. They often do not, but also do not ignore this case, because the people who ignore these cases are the same people who wake up one day and realize the legal ground under their feet has already shifted. This lawsuit matters because it targets a simple idea voters can understand. A rifle does not become unprotected just because it got shorter. If courts accept that idea, a lot of state-level NFA-style bans start looking weak, lawsuits move fast, and the next ruling in this fight could reshape what several states can ban. Subscribe right now so you don't miss the follow-up, because I'll break down the decision the moment it drops and tell you exactly what it means for your state. So here's the bottom line. This New Jersey SBR lawsuit is not just about one state and one gun category. It is a test of whether states can ban a commonly owned rifle configuration based on inches, not conduct. If the plaintiffs win, that could become the blueprint for knocking down similar state bans across the country. And one last thing. Stay smart, stay patient, stay legal. Subscribe if you want clear gun law updates without the hype, and send this to one friend who still thinks an SBR is the same thing as a machine gun. This is general educational content, not legal advice, so always check your state law and talk to a qualified attorney before making any firearm decision.